Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And today's contract tip, we are revisiting the amendment to address concerns with the property as labeled, as titled in the GAR contract package, and amendment to address, amendment during the buyer's right to terminate as labeled or titled in the RE forms contract package. I have done many videos on this. Please check I'll put some links below. Please check the playlist on this YouTube channel for to find some of the other videos, or use the little search. It looks like a little magnifying glass, and put in repairs, right to terminate, and you'll find some other videos, many videos I've done on this topic. But the specific issue that I want to talk about today is you have a buyer and a seller, and they negotiate for the seller to complete some repairs, and a buyer does a walkthrough before closing and those repairs are not complete. Does the buyer have the right to terminate? And the answer is, drumroll please, it depends. But it is not an automatic right to terminate for the buyer. So buyers, just because the seller does not do those repairs that you negotiated, you do not have automatic termination rights. And if you terminate a contract, you might default on the contract and be in breach. So this is a very complicated issue. And there is an article actually this month. If you are a realtor and you get the Georgia Realtor magazine, the fall issue 2019, there is an article regarding the amendment to address concerns, and it specifically addresses it covers a lot of issues that I'm not going to cover all in this video, but it does talk about termination rights for a buyer or lack thereof. And it specifically states that it is also important to understand that courts, and again, this is in Georgia, courts will usually not allow a buyer to walk away from a contract due to the failure of the seller to make minor repairs, particularly when the cost of repairs is minor compared to the sale price of the home. In one case, a buyer tried to rescind a contract to purchase a $600,000 plus home when the seller did not properly repaint a bedroom door. The court refused to grant rescission and held that it was an immaterial breach by the seller on the sale of the home in this price range. The general standard to justify rescission is that the breach must be so substantial and fundamental as to defeat the object of the contract. If the breach is not material, the party is limited to claims for damages. The point is that if a court is going to be reluctant to let a buyer walk away from a contract due to the failure of the seller to correct agreed upon minor repairs, maybe the buyer should not be asking the seller to make such minor repairs in the first place. So as an agent, what do? Well, the first thing you do is really have a good discussion with the buyer about what issues it is that you wish the seller to address in the purchase and sale agreement, and make that very clear how it is that you want the seller to address those repairs. There's other issues with if you say repair or replace, the seller could repair them and then the buyer does a walkthrough and it's not repaired to the buyer's satisfaction. Well, that's another issue that doesn't necessarily give the buyer the right to terminate a contract. Remember that it might be in both parties' best interest to look at the concerns that the buyer wants the seller to address with the house and handle those financially rather than having the work done. So when the buyer moves into the house, the buyer can hire their own contractors and have the work done to their own satisfaction rather than relying on a seller or the seller's contractors to have the work done. So generally speaking, it might be best to handle those financially with financial concessions to one another, or a seller at closing from the seller's proceeds writing a check to a vendor of a buyer's choice to handle those issues. The other thing to consider is if you are going to negotiate for repairs, again, we have addressed this numerous times, you need to go ahead and have the buyer and the seller, at the time you're negotiating for these repairs, agree upon what happens should the seller not perform them. Now, there are a lot of issues why a seller doesn't perform repairs that have been agreed upon early on in the contract. So let's look at it. When is it that this amendment is typically getting signed? Usually it's within the first 7 to 10 to 12 days of going binding. Between that time frame and the time frame that you actually close on the purchase and sale agreement, there are a lot of other issues that come up. There could be something else that gets negotiated based on a lender requirement. The property could come in a lower appraisal price, and the seller and buyer could negotiate on a lower sale price based on appraisal. There are a lot of other, there could be a delay from the seller, a delay. Crickets or cicadas are loud out here today. There could be a delay caused by the buyer's lender. That financially affects the seller. There could be a number of reasons that come into play that financially affect the seller that was not initially in play when the parties agreed to perform these repairs. So when the seller agreed to do these repairs. So there are a lot of issues that come in. So again, the key thing for you as an agent to protect your party and to protect yourself is go ahead and address the potentiality of what happens should the seller not perform or not be able to perform the repairs if you don't handle these financially. We have suggested a lot of special stipulations, and I will again link these below to address seller's lack of performance to give a buyer potential termination rights. And a lot of times the buyer doesn't want to terminate, but they were under the impression the seller was going to repair. So for example, one special stipulation could be all parties agree that the repair work contemplated and agreed upon herein shall be completed not less than 5 business days prior to the closing. All work shall be completed by vendors licensed in the state of Georgia through the proper state licensing boards to complete the work required herein. Seller shall provide buyer at least 5 days prior to closing evidence of vendor's license to do the repair work, invoices, and paid receipts for the work completed. Should the seller not complete the work required herein at least 5 days in advance of closing, buyer shall have the right to either, number one, immediately hire vendors of buyer's choice and have the work completed at the seller's expense to be paid for at time of closing from the seller's proceeds, or 2, terminate the contract agreement with full refund of all earnest money deposits. Another protection could be to escrow some money at closing in order for that work to be paid for, and then it would be paid for out of those escrow funds, and then that unused sums would go back to the seller. Regardless of what a buyer and a seller agree to for the parties' rights with respect to the contract, should the seller not be able to perform the repairs, you need to negotiate that up front on this amendment when you are addressing these concerns. Additionally, the amendment to address concerns is not the form. It doesn't mean send the seller the inspection report and say, see inspection report, do everything. That's not what that amendment is used for at all. So take a look at these amendments in and of themselves. And again, we've done a lot of videos on these forms, but I just wanted to bring to your attention, especially because of the article that came out in the fall Georgia Realtor magazine. And again, there are a lot more issues that is addressed in this article. Again, it's called Repair or Price Reduction, How to Use the Amendment to Address Concerns to Your Client's Advantage. And the amendments themselves, the RE form amendment is called the amendment during the buyer's right to terminate period, and it is form RE 262. And the GAR amendment to address concerns is amendment to address concerns with the property, and it is GAR form F704. It was redone. There is brand new verbiage in there as of the GAR forms revision of June 1st, 2019. That basically adds a time frame, a time limit to this amendment that does coincide with the due diligence period. That was another video I did as well. So thank you guys so much for watching. I hope this contract tip helps you out. Please review the other videos I've done on this amendment and this topic. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.